Here.
Perkins. Rothfuss.
Here.
Salazar.
Here.
Schuler. Scott.
Here.
Steinmetz. Wasserberger.
Here.
Perkins. Excused, Mr. President.
Excused.
Excused. President Dockstader.
Here.
29 present, 1 excused.
Thank you. Prayer by Senator Salazar.
Heavenly Father, we come before you today asking for your blessings on these important issues. We ask for your guidance. We know that we are here because you have put us here for this short period of time to do your will and the will of the people of Wyoming. We ask for your guiding hand in the name of the Savior, the Lord Jesus Christ. Amen.
Senator Scott, would you lead us in the pledge, Senator Scott?
I pledge allegiance to the flag of the United States of America and to the republic which stands one nation, indivisible, with justice for all.
Thank you. Reading correction approval of the journal. Reading clerk, please read the journal committee report.
Mr. President, your journal committee reports that the Journal of March 12 has been read and recommends it be approved. Senator Kolb, Chairman.
Any objections? There being none, the report is adopted. For our new business today, just a reminder that we have the University of Wyoming Family Practice available for medical assistance if needed. We have the number up here. Today in Wyoming history, today is St. Patrick's Day. In 1890, the Sundance Hose Company #1, a fire department, held a grand dance. This is 1890. Whether coincidence or not, late 19th and early 20th century fire departments and police departments were heavily Irish in many U.S. localities. Quote for the day: "Our life is March weather, savage and serene in 1 hour." I think we did it in just one day, Sunday. Session status: this Friday is the last day for bills to be reported out of the committee in the House of the Origin. Next Monday is the last day for Committee of the Whole in the House of Origin. Okay. Messages from the House.
From the House of Representatives, March 12, 2021, message number 199. Mr. President, House Bill number 1, General Government Appropriations 2, passed the House on third reading in an amended form. Ayes 49, noes 10, excused 1. Signed, Wendy Harding, House Chief Clerk.
House bills on first reading. Introduction of House bills. House Bill 1, first reading of the bill.
House Bill 1, General Government Appropriations, sponsored by the Joint Appropriations Committee.
Pursuant to Joint Rule 14-1E, House Bill 1 is referred out to Committee number 2, Appropriations. Appropriations, there you go, you've got it. Okay. Introduction of House bills. House Bill 14, first reading of the bill.
House Bill 14, Rights of Way Along Public Ways Amendments, sponsored by the Corporations Committee. Passed the House, ayes 38, noes 22.
House Bill 14 is assigned to Committee number 7, Corporations. House Bill 33, first reading of the bill.
House Bill 33, engrossed, Interference with Public Contracting, sponsored by the Judiciary Committee. Passed the House, ayes 60.
House Bill 33 is assigned to Committee number 1, Judiciary. House Bill 41, first reading of the bill.
House Bill 41, Interstate Crowdfunding Exemption Amendments, sponsored by the Blockchain Committee. Passed the House, ayes 54, noes 6.
House Bill 41 is referred to Committee Number 1, Judiciary. House Bill 43, first reading of the bill.
House Bill 43, Digital Assets Amendments, sponsored by the Blockchain Committee. Passed the House, ayes 48, noes 12.
House Bill 43 is assigned to Committee Number 1, Judiciary. House Bill 46, first reading of the bill.
House Bill 46, Crime of Bestiality, sponsored by Representative Stiff. Passed the House, ayes 60.
House Bill 46 is assigned to Committee Number 1, Judiciary. House Bill 49, first reading of the bill.
House Bill 49 engrossed, Agency Fee Revisions, sponsored by the Appropriations Committee. Passed the House, ayes 40, noes 18, excused 2.
House Bill 49 is referred to Committee Number 2, Appropriations. House Bill 73, first reading of the bill.
House Bill 73 engrossed, Birth Certificates Gestational Agreements, sponsored by Representative Greer. Passed the House, ayes 43, noes 17.
House Bill 73 is assigned to Committee Number 1, Judiciary. House Bill 76, first reading of the bill.
House Bill 76 engrossed, Uniform Statewide Payment Processing, sponsored by Representative Brown. Passed the House, ayes 56, noes 4.
House Bill 76 is assigned to Committee Number 2, Appropriations. House Bill 85, first reading of the bill.
House Bill 85, Unlawful Dissemination of an Intimate Image, sponsored by Representative Stiff. Passed the House, ayes 60.
House Bill 85 is referred to Committee Number 1, Judiciary. House Bill 87, first reading of the bill.
House Bill 87 engrossed, Provider Recruitment Grant Program, sponsored by the Appropriations Committee. Passed the House, ayes 55, noes 5.
House Bill 87 is assigned to Committee Number 2, Appropriations. House Bill 103, first reading of the bill.
House Bill 103 engrossed, Journalists' Privileged Communications, sponsored by Representative Zwanitzer. Passed the House, ayes 37, noes 23.
House Bill 103 is assigned to Committee Number 1, Judiciary. House Bill 107, first reading of the bill.
House Bill 107 engrossed, Retirement System Efficient Disbursement Method, sponsored by Representative Henderson. Passed the House, ayes 60.
House Bill 107 is assigned to Committee Number 2, Appropriations. House Bill 121, first reading of the bill.
House Bill 121 engrossed, State-Funded Capital Construction, sponsored by the Appropriations Committee. Passed the House, ayes 41, noes 19.
House Bill 121 is assigned to Committee Number 2, Appropriations. House Bill 133, first reading of the bill.
House Bill 133 engrossed, Online Sports Wagering, sponsored by Representative Waters. Passed the House, ayes 32, noes 28.
House Bill 133 is assigned to Committee Number 2, Appropriations. House Bill 148, first reading of the bill.
House Bill 148, Fees Paid to Secretary of State Amendments, sponsored by the Appropriations Committee. Passed the House, ayes 45, noes 15.
House Bill 148 is referred to Committee Number 2, Appropriations. House Bill 150, first reading of the bill.
House Bill 150 engrossed, State Budgeting and Expenditure Authority, sponsored by the Appropriations Committee. Passed the House, ayes 54, noes 6.
House Bill 150 is referred to Committee Number 2, Appropriations. House Bill 179, first reading of the bill.
House Bill 179 engrossed, Optional Municipal Tax Election, sponsored by Representative Zwanitzer. Passed the House, ayes 32, noes 28.
House Bill 179 is assigned to Committee Number 7, Corporations. Reports from standing committees.
March 17, 2021, Mr. President, your committee number 10, Labor, Health, and Social Services, to whom was referred House Bill 111 engrossed, Access to Anatomical Gifts and Organ Transplants. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes, Senators Baldwin, Furphy, Hutchings, and McEwen. Excused, Senator Bouchard. Senator Baldwin, Chairman.
Bills on second reading. Senator Baldwin.
Thank you, Mr. President. I would like to request a re-referral of House Bill 38, Community Behavioral Health Priority Populations, to Committee 7.
Absent objection, House Bill 38 will be referred to Committee Number 7, Corporations. See how bills on second reading. Senate File 66, second reading of the Senate file.
Senate File 66, Slayer Rule applied to joint ownership.
There are, Senator Perkins.
Mr. President, there is an amendment on that. If we could just lay that back to the end, I think it'll be out by the time we finish second reading.
Thank you. Absent objection, we'll lay that back till the end. Let's continue then. Senate File 113, second reading of the bill.
Senate File 113, Business Ready Communities Amendments.
There is an amendment. Reading clerk reading the amendment, please.
Senate File 113, second reading amendment number 1, page 3 after line 4 in.
Senator Wasserberger.
Thank you, Mr. President. I move second reading amendment number 1 to Senate File 113 and would ask for your favorable support. If you look at the amendment, it simply crosses out written opinion, I believe, and inserts review. And so essentially, the Attorney General's office would not be required to issue a formal letter. It would be able to issue a review, which they already do in statute. This just makes it plain and simple in this particular part of the statute that they are going to review each project proposed to the business-ready communities. So I ask for your favorable aye vote.
Questions or discussions on the amendment? No further discussion. All those in favor say aye.
Aye.
Those opposed, nay. The amendment has passed. We are back on the bill. Senate File 113, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 146, second reading of the Senate file.
Senate File 146, 6-person juries in civil cases.
There are no amendments. Senate File 146, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 147, second reading of the Senate file.
Senate File 147, Management Council Authority and Legislative Committees.
There are no amendments. Senate File 147, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senator Perkins, are we ready with that amendment? We'll go back and read it in just in case.
Amendment out. I went back and Mr. President, I had approved that amendment last week, but as we looked today, it wasn't there. I went back and checked and they were in the process of going to put that out and they just, I don't know, it fell in a crack somewhere. So
How do you
with
feel
that,
about
Mr. Chairman,
laying it back a day?
I'll just lay that, if I could, I'd just lay that back one day.
Okay, absent objection, that file, Senate File 66 will be laid back a day. Done. Third reading consent list. Mr. Majority Floor Leader, do you have a consent list?
Mr. President, we do have a consent list. I move third reading consent list, which is as follows. Senate File 38, Decentralized Autonomous Organizations. Senate File 39, Digital Identity. Senate File 58, Wyoming Investment in Nursing Funding. Senate File 75, Protective Orders Amendments. Senate File 107, Transportation Statutory Amendments 2. Senate File 114, State Land Leases. Senate File 116, Wyoming Business Council Directors Reduction. Senate Journal 3, Federal Suspension Orders on Oil and Gas Production.
Would anyone like any of these bills removed from the consent list? Senator Ellis.
Mr. President, may I have Senate File 114 removed from the consent list?
Moved. Moved, okay. Any further bills to be removed from the consent list? Senator Perkins?
Thank you, Mr. President. If I could, I'd ask that Senate File 58 be removed from the consent list. There's supposed to be an amendment there too.
All right. Absent objection, Senate Files 58 has been removed from the consent list. Any further to be removed from the consent list? All right, having been read 3 separate times, the question is, shall these bills pass the Senate? Senate File 38, Decentralized Autonomous Organizations, Blockchain Technology. Senate File 39, Digital Identity, Blockchain Technology. Senate File 75, Protective Orders Amendments. Senate File 107, Transportation Statutory Amendments number 2. Senate File 116, Wyoming Business Council Directors Reduction, Senate Joint Resolution 3, Federal Suspension and Orders on Oil and Gas Production. Chief Clerk will call the roll.
On the consent list. Anderson.
Aye.
Aye. Baldwin. Beitman. Boner.
Aye.
Bouchard. Case. Cooper. Driscoll. Ellis.
Aye.
French. Murphy. Guru. Hicks. Hutchings. James.
Aye.
Kinsky. Cole. Cost. Landon. McEwen. Nethercott. Pappas. Perkins. Rothfuss. Salazar. Schuler. Scott. Steinmetz. Wasserberger. President Dockstader. On the consent list, 30 aye. Senate File 38. Are there any changes? Hutchings, aye to no. Steinmetz, aye to no. Closing vote. Closing. Vote closed. Senate File 38, 28 aye, 2 no. Senate File 39, are there any changes? Hutchings, aye to no. Steinmetz, aye to no. Closing vote. Closing. Vote closed. Senate File 39, 28 aye, 2 no. Senate File 75. Are there any changes? Closing vote. Closing. Vote closed. Senate File 75, 30 aye. Senate File 107. Are there any changes? Closing vote. Closing. Vote closed. Senate File 107, 30 aye. Senate File 116, are there any changes? Closing vote. Closing. Vote closed. Senate File 116, 30 aye. Senate Joint Resolution 3, are there any changes? Closing vote. Rothfuss, aye to no. Perkins, aye to no. Closing vote. Closing. Vote closed. Send Joint Resolution 3, 28 aye, 2 no.
Having received the affirmative vote of the majority of the members elected to the Senate, Senate File 38, Decentralization, Autonomous Organizations, Blockchain Technology, Senate File 39, Digital Identity, Blockchain Technology, Senate File 75, Protective Orders Amendments, Senate File 107, Transportation Statutory Amendments 2, Senate File 116, Wyoming Business Council Directors Reduction, Senate Joint Resolution 3, Federal Suspension and Orders on Oil and Gas Production have passed the Senate. Let's just check. We generally go back to numerical. If we went back to Senate File 58, Senator Perkins, is your understanding we have that amendment distributed?
Yes.
Okay. Let's go back then.
Mr. President, before we start that, may I approach the short privilege of the floor?
Please do.
Thank you, Mr. Chairman. Under our rules and our tradition, we're able to stand up and announce, or we can express why we voted no on an item on the consent list. I voted no on Senate File 147 for the reasons that I talked about briefly during committee of the whole debate, and that is the longer I've been here, the more I think that resolutions don't count. While I am absolutely sympathetic and support the intent and the spirit and the content of that particular resolution, at the end of the day, the resolutions, I just don't think, at the end of the day, I think they go in a round file and I don't think they make a difference. And so, it used to be when I first came down here that a lot of the old guard just always voted against those. A number of past presidents that we all remember very fondly. And as I've been here longer, I start to see the wisdom in that. So thank you, Mr. President. Mr. President, I guess we're on Senate third reading amendment number 1 to Senate File 58.
Yes.
Could we have that read in, please?
Let's just for the record and those listening, we are now on Senate File 58, Wyoming Investment in Nursing Funding. Third reading of the bill. Would the reading clerk read it in, please, for the record?
Senate File 58, Wyoming Investment in Nursing Funding, sponsored by the Education Committee, an act relating to the administration of the government.
Senator Perkins, would you move the amendment and explain the amendment?
Thank you, Mr. President. Mr. President, I move third reading amendment number 1 to Senate File 58 and ask the body to vote aye. Mr. President, what this is mentioned this a little bit during discussion of the budget bill, that we were trying to find a way to do budget balancers on all the bills that are attempting to appropriate both, I'll call it COVID 1, which was the COVID money, the COVID relief bill that came out last year, and I'll call COVID 2, the one that was just signed last week. And so this is an attempt to provide standard language that we want to try and put in every amendment that commandeers those. If you remember back in our discussion on a budget balancer, to do this, the plan is simply that we stripping the appropriations out of these bills that the governor has on the remaining COVID funds. The governor has authority to distribute among that, and the new COVID funds. The anticipation is that your appropriations committee, your joint appropriations committee, will make a number of recommendations about how the COVID 2 money ought to be divided up and spent. Then that will end up being brought to the body and voted on, so that everybody will have the opportunity to weigh in on how those appropriations are divided up and what that money is spent on. And so this is an amendment that I think you'll see that the bills that we passed through that already did that, you'll see similar amendments like this in the other body, and you'll continue to see amendments like this on the House bills that come over here that have the same amendment. So again, this is brought to us by staff, and what it does is it goes back in and basically deletes that ability. Again, the budget bill will take care of the budget balancer, and the budget bill will take care of that. And then ultimately what you see as the sunset here is the budget bills, and what we're doing will not last past the end of this biennium. And so it will terminate at the end of this biennium. And then all of those things, if those programs continue, will be reappropriated and will be authorized for the next biennium in the next budget bill. And so that's what this amendment does. And with that, I'd be happy to stand for questions. Thank you, Mr. Chairman. Mr. President.
Questions and discussion on the amendment. Senator Scott.
Mr. Chairman, and I confess I got this amendment about 60 seconds ago, so I'm not as up to date on it as I might be. Mr. Chairman, I think I'm going to agree with the basics of it. As I understand it, what it does is it lets this program share in any of the CARES Act that has, the original CARES Act that was carried over, some kind of proportional share, and I believe there was a provision in the budget bill, Mr. Chairman. And then we'll consider, if we get more, we'll consider doing more by appropriation. Mr. Chairman, the question I have is on line 20, the amendment, section 2. I believe that was also in the standing committee amendment and passed there. I don't think, my question is, does it do any harm if we pass it twice? Because I think that's what we're doing here. I certainly agree with it, but it's a technical question as to whether that's a problem or not. If we pass the same thing twice, and it might be with slightly different lines or something.
Thank you. I would suggest, Senator Scott, that you're the most qualified on the floor to address a 62nd amendment. Let's proceed now. Further questions and comment on the amendment? Further discussion? Senator Perkins, it looks like it's going back to you.
Thank you, Mr. Chairman. I will double check with staff if that's a technical correction, then we'll do that as it moves, as this bill continues to move through the process. But I know we went in and I've had numerous discussions with LSO about this, and particularly with the director of LSO trying to resolve this issue about there are a number of bills out there appropriating from these same funds. And so in working that, we've tried to come up with some standardized language that we'll start trying to put in these bills as they move through. And again, if this is one of the bills that was listed by name in the budget balancer. And so with respect to whether or not, if we repeal it twice, is it extra repealed? I'm not sure the answer. I'll make sure I bring that to staff's attention. So as this bill moves through, if there's an additional technical correction needs to be made, that it's done.
Thank you, Senator. We are on third reading amendment number 1 to Senate File 58. Are you ready for the question? Question is, shall the amendment pass? All those in favor say aye.
Aye.
Those opposed, nay. We are back on the bill. Senate File 58. Having been read 3 separate times, the question is, shall Senate File 58 pass the Senate? Chief Clerk, call the roll.
Senate File 58, third reading roll call. Anderson?
Aye.
Aye. Baldwin? Aye. Beitman? Aye. Boner?
Aye.
Aye. Bouchard? Aye. Case? Aye. Cooper? Aye. Driscoll? Aye. Ellis? Aye. French? Aye. Murphy? Aye. Guru? Aye. Hicks? Aye. Hutchings? No. James?
Aye.
Aye. Kinsky? Aye. Cole? Aye. Cost? Aye. Landon? Aye. McEwen? Aye. Nethercott? Aye. Pappas? Excused? Perkins?
Aye.
Aye. Rothbus? Aye. Salazar? Aye. Schuler? Aye. Scott? Aye. Steinmetz? Aye. Wasserberger? Aye. President Dockstetter?
Aye.
Aye. Closing vote. Closing. Vote to close. Senate File 58, 28 aye, 1 no, 1 excused.
Having received the affirmative vote of the majority of the members elected to the Senate, Senate File 58, Wyoming Investment in Nursing Funding, has passed the Senate. Senate File 114, third reading. Oh. Okay, we'll move Senate File 114 down to numerical order in third reading. Bills on third reading of the Senate. Senate File 100, Internet Freedom Prohibiting Discrimination. Reading clerk, read the.
Senate File 100, Internet Freedom Prohibiting Discrimination, sponsored by Senator Steinmetz, an act relating to trade and commerce.
There are no amendments. Are you ready for the question? Senate File 100, Internet Freedom Prohibiting Discrimination. And we had read 3 separate times. The question is, so the bill passed. The chief clerk will call the roll.
Senate File 100, roll call. Anderson?
Aye.
Aye. Baldwin? Aye. Beitman? Aye. Boner?
Aye.
Aye. Bouchard? Aye. Case? No. Cooper? Aye. Driscoll? Aye. Ellis?
Aye.
Aye. French? Aye. Murphy? Aye. Guru? No. Hicks? Aye. Hutchings? Aye. James?
Aye.
Aye. Kinsky? Aye. Cole? Aye. Cost? Aye. Landon? Aye. McEwen? Aye. Nethercott? No. Pappas excused? Perkins? Aye. Rothbus? No. Salazar? Aye. Schuler? Aye. Scott? Aye. Steinmetz? Aye. Wasserberger?
No.
No. President Dockstetter? Aye. Closing vote. Closing. Vote closed. Senate File 100, 24 aye, 5 no, 1 excuse.
Senate File 100, having received the affirmative vote of the majority of the members elected to the Senate, Senate File 100 has passed the Senate. Senate File 114, third reading of the Senate file.
Senate File 114, State Land Leases, sponsored by Senator Boner, an act relating to state lands.
There is an amendment. Senator Ellis.
Oh, I don't have an amendment,
Oh,
sir.
okay. No amendments. Senate File 114. Oh, please, Senator Ellis.
Thank you, Mr. President. I don't have an amendment, but I just, as I was studying some of these bills as, over the weekend, the long weekend in between shoveling snow, I just wanted a little more discussion about creating this preferred right. I understand what the bringers of the bill are intending to do. You know, we do have criteria when it comes to state land. And, you know, existing statute creates a preference for certain individuals who are located or have operations located those vacant lands. But as I've been reading this bill and just kind of thinking about it over the weekend, I just don't know that I have a full understanding of what this right means. And so if I could just have a little more discussion, and I apologize, the bringer of the bill is here with us electronically, so I couldn't catch him this morning. But just a little more discussion, because I am a little uneasy about creating, as you'll see in the bill, a preferred right. My understanding is that these vacant lands, the purpose of them is for Wyoming to in part generate revenue. And so when we start creating these preferences, you know, certainly fair market value conditions might change going forward in the future. And I just want to make sure we're not locking in preferred rights and missing out on perhaps lost revenue by creating those rights. So a little more discussion on this bill, Mr. President.
We
Thank you.
are on Senate File 114, state land leases. Let's go to the electronic version of Senator Boner. Senator Boner.
Well, thank you, Mr. President. I'll do my best to kind of juggle between my single screen I have and my amendment, the committee of the whole amendment I just printed out. To reiterate what we discussed on committee of the whole, we're not creating any new rights. It's so want to make that abundantly clear. Right now, there's 2 concepts that you will find throughout our statutes when it comes to enduring the greatest benefit to beneficiaries. Obviously, the most obvious one is dealing with getting as much money as possible, but you also see that there's a preference in there where the individual closest to the land, it presumably is going to be the one that's going to care for it the best. And so that's also a benefit to the trust beneficiaries, just the day in and day out of actually managing the land in a competent manner. So it's not creating any new right. It differentiates between vacant land and land that already has a lease on it that's up for bid, whose lease is expired. And as that the new language with preferred right is dealing with, I believe, bids that are not expired, they're not vacant, but are up for lease nonetheless. It's just differentiating between the two because they are different. And that differentiation when you see that preferred right language. It was at the request of state lands to make sure that they had a clear understanding that these lands will be treated differently based on whether they're vacant or whether they're not. So no real changes. The biggest change here is with the procedure for vacant lands, making it very prescriptive, and they you can imagine how a difficult situation state lands and our board of land commissioners would find themselves in if you have two neighbors competing over the same piece of vacant land where no one entity has a preferred right to it because they currently hold the lease. And so all that the bill does is it goes through and it makes it very clear and provides some finality to that particular situation with a live bid. That's the biggest new concept, is the live bid between two adjoining landowners competing over the same vacant piece of property. So I wouldn't get too hung up on the exact language. This is one of these bills where every attorney that looks at it wants to provide their little, provide their words that are going to be perfect, and those words vary depending on the attorney making the input. So just want to make sure that everybody knows that the biggest change here is looking in that committee of the whole amendment, and with a more defined process for these really tough situations with vacant lands. So hopefully that answers the question, and certainly stand for any additional questions.
Further questions for the sponsor, Senator Landon?
Thank you, Mr. President. Appreciate the opportunity to rise and visit a little bit about this bill. We were late into the evening on committee of the whole, and the good sponsor did a great job of explaining the bill, and we really didn't have much of an opportunity. So I'm glad to rise in support of the bill. Mr. President, this is an issue that I think is maybe more important than we have realized. We have a lot of folks sweeping into our great state of Wyoming with the intention of gobbling up our resources and our lands and our views, and that's a wonderful thing because they're starting to discover what we've known all along. But this past interim, I had a very good friend of mine who actually resides down in the good chairman's district. And so I struck up a conversation with the good senator, and the result ultimately was this bill. And it's because of this. We had a young ranching family who sits on property that is next to one of these state leases. And for years and years and years, that particular ranch had benefited from that grazing lease. The ranch changed hands a couple of times, and they were able to get the ranch back. And for about 10 years, they tried to work with our state agency and be allowed to bid so that they could benefit from that grazing lease again. Never could get that to open up, never could get that to happen, even though it was their fence that fenced in the property. And so finally, our state agency let this piece of property out for bid, and a multi-state conglomerate came in and gobbled up the lease, bidding something like 4 times what it is actually worth. So that's what's really going on out there, Mr. President. And the concern that the good senator and I had is that some of this is the fabric of our communities. We have local families who are trying to make it in the agriculture business, and we just wanted the opportunity for folks like that to at least be able to have an additional hearing or the opportunity to match a bid. We think that's appropriate, and it protects our constituents out there. So I hope that gives a little bit more background as to why. And boy, the senator did a great job of drafting this bill and carrying it this far, and I hope you'll support it. Thank you, Mr. President.
You, Senator. Further discussion? As Senator, the secret is out on an absolutely tremendous state. So with that, there's no further. Oh, Senator Perkins.
Mr. President, so that begs an interesting question, and I understand some of the problem. I mean, but if I understand, as I read the lease, all it takes for it to be, one, it only applies to vacant lands, or at least this bill does. or creates vacant lands. And so it only creates a preference on vacant lands. If I've got this right. And a vacant land just means one that is not currently subject to a lease. So it must either it's either hasn't been under lease or the lease has expired. And so as you talk about that, and I understand how this works, and and over the years have assisted a lot of clients in trying to protect, and a lot of these school sections and other sections that would be subject to this come right in the middle of a larger private holdings, or just in holdings that are kind of surrounded by, and it makes really not a lot of sense for anybody else to use it or have it. And certainly creates, if you don't have something like this, it creates a significant opportunity for mischief, because somebody just can come in. And there are some people who, believe it or not, Mr. Chairman, Mr. President, who just don't like cattle grazing, don't like livestock grazing. And if they have the opportunity to just come in and pick off a parcel as a result of, because they've got a deep pocket donors who believe the same thing that they do, and they can start to lock those up. So that's one side of the equation. But the other side of the equation, and my question to the proponents of the bill are, the other side of that is that these are school lands, and there's a fiduciary obligation state to maximize money that comes off those to the land, to the goals, because these are a part of the Common School Permanent Land Fund, and the rents that are received off this go directly in support of our schools. So I'm just wondering, and I would like to know what they've done to try and balance the rights and the obligations and the duties with respect to good stewardship, and making sure the land is husbanded correctly and grazed correctly, and balancing this when there is a higher bid, but maybe from a less desirable and this preference. How does the state discharge its fiduciary obligations with respect to school lands?
Take it back to Senator Landon.
Thank you, Mr. President. And the prime sponsor may have some comments in this regard too, but certainly that was part of the conversation throughout the 6 or 8 months that we dealt with this situation up in the center part of the state. And it's actually come up a couple of times in my county as well. And therein lies the policy decision for us, because the chairman of appropriations is right. If we just cut straight to the point, these state lands are to benefit our schools, and we should get absolutely the best price we can get. Or maybe we don't want to do that. And that's what this bill suggests, is that there are times when we need to help our constituents to at least have an opportunity to hang on to a grazing lease that may be so important to their ranch that it might help keep them above water. That certainly is, though, the policy decision for us. I think the provisions in the bill do allow us to make sure that somebody can match a bid. If that bid is way above, maybe some of our constituents can't match the bid, but it gives them an opportunity. So thank you, Mr. President.
Thank you, Senator Hicks.
Yeah, Mr. President, I'll take a stab at that question from the 30,000 foot view. This really started maybe about 20 years ago in a state to our west, where we had organizations that are just totally anti-animal agriculture coming in and leasing up large blocks of state land in that state, and then resulting in the retirement of those from any livestock grazing. But those lands that they were acquiring and retiring the grazings were integral parts of those operations. So the net effect of that is you had a decline in the economy because you had a decline in production. You also had a net decline in the real estate value associated with those ranches that had significant state land holdings. So how does that benefit the trust? As those property taxes assessed on those local mills, when you depreciate the private property associated with that, by losing those state AUMs in that grazing operation, you decrease that property as a net reduction to the schools, but because of the 12 mills net assessment on the property valuation. So that's the 30,000 foot view. And we do have situations where we have agricultural business operations that have substantial holdings of state lands. That would be the net effect of that. And so that's the 30,000 foot view. The other side of that is it's just the overall economic value of reduction of the number of animal unit months that circulates back through that community in sales and use tax. You depreciate the value of those lands, private lands. You reduce the commerce associated. We know, looking at some of the statistics from the University of Wyoming of ag economics, that every dollar generated locally turns over usually 2 to 3 times in those communities. So you lose those revenues and those jobs associated with that. But the big picture thing is the associated decline of the value of those private lands associated with those state grazing leases, which directly affects the property value and the taxes that go to the K through 12 foundation program.
Senator Grew.
Thank you, Mr. President. On 4, interesting notion. What I'm hearing is that value has different meanings to different people in different situations. Not just necessarily a total aggregate dollar value, but a value to the surrounding landowners, to the community itself, to operations that are involved in those lands, and to maybe an industry, maybe a way of life. And so that value may be calculated a little bit differently. I believe in that. And I think we'll be hearing more about it. On 4, thank you.
Senator Scott.
Mr. President, I want to make very clear, I have a conflict of interest in this bill and have declared it. But the debate raised one issue I wanted to speak to just a little bit from the perspective of somebody in the business. The risk of the land falling into the hands of somebody who is so opposed to animal husbandry, who essentially wants to do away with livestock business, and somebody who would take this land and just leave it idle. There is a real risk that the process in our arid country will degrade the quality of the land, Mr. President, significantly. There's increasingly a lot of agriculture is going to various rotation grazing systems. There's a lot of work been done by a particular gentleman who's I don't want to say the proper name on the floor, but essentially he's shown, at least to my satisfaction, that in the arid lands that we have here, if you do not have the land, Mr. President, grazed by livestock, they tend to not be as productive. That the action of the hooves, essentially tilling the soil, planting the seeds, removing old vegetation, which doesn't rot in our very dry climate, is essential to keeping up the quality of the land. And there are exclosures that the university, in cooperation, I believe, with the BLM, has set up all around the state. And I watched the ones in our area, and the ones where they have been successful in keeping the livestock out are gradually declining compared to the things outside the fence. Sometimes the university needs to go back and take a look at those, quantify that, and be systematic about it. But if you simply go to a highest bidder system that opens it to people who will not use it properly, you are asking to have that resource degraded both from an environmental and an economic perspective. And, you know, I know, Mr. President, I've got a conflict, but I thought it was wise for somebody who is actually in that business to stand up and speak to that and be blunt about it, because that's a risk you run if that happens.
Senator Landon, and then over to Senator Driscoll, and then to Senator Cooper in that order. Senator Landon.
Thank you, Mr. President. Just another quick comment. Really appreciate the discussion about this bill. I think it is important. You know what makes me feel badly sometimes, Mr. President, is that sometimes we come down here in a reactionary mode. We're not really very good at being proactive, but we sometimes react okay. And that's really what this bill does. It breaks my heart that a small ranch up in the middle part of the state has been impacted perhaps forever with the inability to have an adjacent lease, which happened to be open for all that period of time. They tried to get us to lease it to them and couldn't. Finally got open for bid, and away it goes to some out-of-state conglomerate. So what we're doing here with this bill, we're putting up a stoplight after the wreck. And that kind of tugs at my heart a little bit, Mr. President. But still, I think if we can help to avoid a situation like this in the future for some other ranch, maybe in your district, this bill is very worthwhile. Thank you.
Thank you, Senator Driscoll.
Mr. Chairman, thank you. I too will declare conflict. I'm a holder of a number of state leases and will declare conflict. However, I feel this is a good bill. I've been involved with some of these vacant land deals. They are difficult to say the least. And this is a good step towards helping solve it and keep our good working ranches intact.
Thank you, Senator Cooper, and then to Senator Ellis.
Thank you, Mr. President. I'd like to reiterate what the good senator from Page Creek said. I too will declare conflict, but had a long discussion with my range con from the BLM. The place I have is a mixture of BLM, state, and deeded land, and it's all stirred up. We have access problems, we have a lot of other issues, but we're in a what's called a range management plan with NRCS, and that allows for a grazing rotation on this large pasture. The NRCS agent and the BLM range con both said we need to get more grazing down here. This land is degrading because we're not using it enough. So we completely redesigned our RMP to make sure we did get the grazing where it needed to be. It is really important that these lands get used. That maintains the quality of the excuse me, of the forage and the overall health of the land. Thank you, sir.
Senator Ellis.
Thank you, Mr. Chairman, or Mr. President. I appreciate all the discussion. I think it helped clarifies. I think my concern is just the departure of how the bill came to us on the floor and the effect that the committee of the whole amendment had on the bill. You know, certainly I understand the bringer's intent, but I do think that is important for us to have this discussion because it is our obligation to make sure we're maximizing revenue from these state sections. And so I continue to have some concerns about this bill, Mr. President. Just wanted to say I appreciate the discussion.
Thank you, Senator Ellis. Are you ready for the question? We are on Senate File
Mr. President.
Whoop. Oh, sorry, Senator Bono. We about run over top of you. Go ahead.
Well, Mr. President, thankful for this very unexpected discussion here on third reading. If somebody's concerned about how the bill works, I just point out that there should be a paper handout that tracks in all the changes. I wanted to spell something that's simply not true. We are not, there's no policy in here that will allow for less money going to the state beneficiaries. All that it does is it allows somebody who qualifies for the preference to meet the highest bid. So in that situation where you have somebody coming in and bidding a very high bid, that's going to be the high bid. We're just giving that individual or entity that qualifies for the preference an opportunity to meet it. So there's nothing in here in the bill that actually will reduce the amount of revenue to the state, not that I can tell. if anything, there's been concerns that having the live auction will increase the amount of revenue to the state from our ag producers. That's a very minor concern. I don't think is well founded, but there's just nothing in this bill, so we can get focused on what the bill does. Again, I think that discussion was a little wandering and not as focused on what the bill actually does. All that we're doing is we're reinforcing a concept that is already in statute, talking about preferences that already exists. We're just defining it. We're defining what vacant land, and this bill is important. We've got lots of feedback from our Board of Land Commissioners, our 5 statewide elected officials, who appreciate the clarity that's in this legislation. And it's really important that it move forward. On a final note, Mr. President, I point out that I do not have a conflict because I do not have an ownership interest in any entity that actually owns land here in the state. I work for one, but I'm not an owner as such. I believe I do not have a conflict. Furthermore, we don't have any vacant leases near our property where we're adjoining landowners. Once again, all that we're doing is we're defining the process for vacant lands in a way that is clear to everybody. We're providing for notification for adjoining landowners. We're cleaning up the process. That's all this bill does. There's nothing in here that's going to decrease the amount of revenue to state lands and to the trust beneficiaries. So if anybody has any questions, please give me a call. My cell phone still works. I'm a little concerned that the discussion got off rails on what this bill does and doesn't do. It's important that it moves forward. And I encourage you to vote aye.
Okay, we've heard from the sponsor. Ready for the question? Question being called. Senate File 114, state land leases. Having been read 3 separate times, the question is, shall the bill pass? Chief Clerk will call the roll.
Senate File 114, roll call. Anderson.
Aye.
Aye. Baldwin. Aye. Beitman. Aye. Boner.
Aye.
Aye. Bouchard. Aye. Case. Aye. Cooper. Conflict. Driscoll. Conflict. Ellis. No. French. Aye. Murphy. Aye. Guru. Aye. Hicks. Aye. Hutchings. Aye. James.
Aye.
Aye. Kinsky. Aye. Cole. Aye. Cost. Aye. Landon. Aye. McEwen. Aye. Nethercott. Aye. Pappas. Aye. Perkins. Aye. Rothfuss. Aye. Salazar. Aye. Schuler. Aye. Scott. Conflict. Steinmetz. Aye. Wasserberger. Aye. President Dockstetter. Aye. Closing vote. Closing. Vote closed. Senate File 114, 26 aye, 1 no, 3 conflict.
Senate File 114, state land leases, having received the affirmative vote of the majority of the members elected to the Senate, Senate File 114 has passed the Senate. Next file up for our consideration, Senate File 143, school finance funding model amendments, 3rd reading of the Senate file. Reading clerk, read the bill.
Senate File 143, School Finance Funding Model Amendments, sponsored by Senator Scott, an act relating to school finance.
Senator Scott.
Mr. President, I'm aware of several amendments out there that are still in development, and I ask the bill be laid back for one day.
That's right. Absent objection, Senate File 143 will be laid back one day. Bill is laid back, file is laid back. Bills on 3rd reading, consideration of bills on general file. Mr. Majority Floor Leader, are we ready for that order of business? Consideration of bills on general file?
Mr. President, move that the Senate resolve itself into committee of the whole.
You've heard the motion. All those in favor say aye. Those opposed, nay. Senator Baldwin, you're in charge of the Senate.
Committee of the whole will please come to order, you bunch of rowdy people. The first bill, or first Senate file for our reading is Senate Joint Resolution 2. The reading clerk will please read in the bill.
Senate Joint Resolution 2, Convention of States, sponsored by Senator Beitman. A joint resolution requesting Congress to call a convention for proposing amendments to the United States Constitution as specified. Was referred to committee number 9, which returned a committee recommendation that it do pass. Ayes Senators Beitman, Cooper, and Wasserberger. No Senators Anderson and Rothfuss. Senator Anderson, Chairman.
You've heard the reading of the bill. What is your pleasure? Chairman Anderson.
Mr. Chairman, I move that when the committee of the whole rises to report, they do so with a favorable consideration for Senate Joint Resolution 2, Convention of States.
And Chairman Anderson, who would you like to explain the joint resolution to us?
Senator Beitman, I'm sorry. Yes.
Senator Beitman, the floor is yours. Oh, I'm sorry. It's the first day on the job, okay? Go ahead, Senator
Thank you,
Beitman.
Mr. Chairman. Happy St. Patrick's Day. Ladies and gentlemen, I bring you Senate Joint Resolution number 2, Convention of States. This is a joint resolution requesting Congress to call a convention for proposing amendments to the United States Constitution. Typically, we see resolutions that just proclaim we're thinking a certain way, or we want to see something happen. Well, this resolution actually does something. It's part of our constitutional process. There are 2 ways we can amend the Constitution of the United States under Article 5. Every way we've done it so far, all 27 amendments have been through Congress. Article 5 also provides another avenue for the very situation we find ourselves in right now. And that is when we have a runaway Congress and a runaway judiciary and a runaway executive branch in Washington, D.C. The states can get together and bypass Congress and get together and propose amendments to the Constitution. And that's what this bill does. So ladies and gentlemen, I'll walk you through the bill. Pages 1 through 2, we have our whereases. We can read those to ourselves. The meat of the bill is on page 2, section 1. This is the call for the Convention of States to propose amendments. This is what 15 other states have done. This language is identical to their call. It takes 34 states to get this thing going. Section 1, the legislature of the state of Wyoming hereby applies to Congress under the provisions of Article 5 of the Constitution of the United States for the calling of a convention of the states, limited to proposing amendments to the Constitution that impose fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, and limit the terms of office for its officials and for members of Congress. So 3 things that are germane to this call: limit the power and jurisdiction of the federal government, limit the terms of office, and provide fiscal restraint. So those are the 3 areas that if we do get this convention called and all the states get together to meet and to discuss these amendments and start drafting these amendments, the amendments on the table will be dealing with fiscal restraints, whether we're looking at spending caps, whether we're looking at a balanced budget amendment, things of that nature, anything that limits the power and jurisdiction of the federal government, and term limits, which is overwhelmingly popular amongst Democrats, Republicans, and independents. It's something that the whole country can actually agree on, that we need term limits, not just for Congress, but for the bureaucrats and the federal officials and federal judges. We need to drain the swamp, and the swamp's not going to drain itself. We've seen that. The way to do it is for the states to do it. And this is the only way possible that we can get a term limits amendment that actually has teeth, that actually limits the bureaucrats and not just the representation. Section 2 is kind of comes with the subject to the following reservations, if you will. An application on line 12, page 3, an application Congress, of the United States, to call a convention pursuant to Article 5 for the purposes of proposing amendments to the Constitution confers no power to Congress other than the power to call. Romanet 2, Congress shall call an amendment convention only upon the receipt of applications for an amendment convention for the substantially same purpose. Remember those three things I outlined in section 1 from 2/3 of the legislatures of the several states. Number 3, Congress does not have the power or authority to determine any rules for the governing of the convention of states, nor does it have the power to set the number of delegates. The power to name delegates remains exclusively within the authority of the legislatures of the several states. Number 4, by definition, a convention of the states to propose amendments to the Constitution, the states shall vote on the basis of one state, one vote. Number 5, a convention to propose amendments pursuant to this application shall be limited to considerations of the topics specified in the joint resolution and no other. Comes with an express understanding that any amendment that seeks to amend, modify, or repeal any provision of the Bill of Rights shall not be authorized for consideration in any matter. Number 6, pursuant to Article 5, Congress may determine whether proposed amendments shall be ratified by the legislatures of the several states or by ratifying conventions. The legislature of the state of Wyoming recommends that Congress select ratification by the legislatures of the several states. Number 7, the legislature of the state of Wyoming may provide further instructions to its delegates and may recall its delegates at any time for a breach of duty or a violation of the instructions provided to the delegates. Section 3 just goes on to say this is a continuing application until we hit 2/3 of the states or until we repeal or rescind this call. And section 4 calls on the Secretary of State to submit copies to those in Washington, D.C. Now, when I first voted on this, my freshman year in the House in 2017, our national debt was $19 trillion, and it was unfathomable at that time. And we heard the gnashing of the teeth and the crying about run away this, run away that, this thing can't be controlled, we can't do this. There's got to be a better way, we got to elect better people. So we did, we elected what we thought were the right people. Here we are, 2021. $28 trillion is the national debt today. 28 trillion. We are on the wrong track, ladies and gentlemen, and this thing is not going to fix itself. Burying our heads in the sand and hiding from this problem is only going to make it worse. The longer we wait, the worse it's going to get. It's already gotten worse in my short time in office, and we can't do this to our children. We cannot. We cannot let this country continue on this course to ruin. Our federal government is absolutely overstepping its boundaries with the aid of the Supreme Court. So in order to get these branches of government and restore federalism to this country, I believe an Article 5 Convention of States is the method to go. I think it's safer than nullification. We can do both at the same time, but we have to do something. We cannot just sit here and keep kicking the can down the road. So I know I'm probably not going to change too many hearts and minds today. Those of you that have been in office long enough, we've debated this thing to death. But I ask you to think about this and give it some thought. And I'll stand for any questions, Mr. Chairman. Thank you very much.
We're on Senate Joint Resolution 4, discussion. Senator Salazar.
Thank you. Thank you, Mr. Chairman. I would just like to echo the same words of my colleague. I also was a freshman in the other chamber in 2017. But I support this. This country is in trouble with our national debt. And to those of you who have children and grandchildren, they're going to be left with the bill. This is something that I support. This is something that my constituency supports. And I will caveat my support by saying that there are those on the other side who I highly respect. who I agree with almost all the time with, and yet in this situation, there's a difference of opinion. But I do appreciate the civil discourse that we've had amongst ourselves of agreeing to disagree. But I believe that this is the right course for our state and for our nation. And I also would ask for your support in this. Thank you.
Mr. Chairman, point of order.
Go ahead.
I think you said we're on Senate Joint Resolution 4, but we're really on Senate Joint Resolution number 2.
You are correct. Thank you very much, Chairman Anderson. I'm getting in a hurry. That's the next one. Senate Joint Resolution 2. Further comments? Senator Case.
Thank you very much, Mr. Chairman. Mr. Chairman, I rise in support of this resolution. And I look at a landscape of America right now. And I think this resolution is needed more than it ever has. I think about, when our Constitution was formed and how divided our country was and how we had great civil debate about the forming of a federal system of government as we moved away from the Articles of Confederation. And this tool was put in the toolbox. And you recall that the great compromise of the Constitutional Convention, one of the greatest ones was the way that apportionment or representation was established in the United States Senate, giving each state 2 senators. And at the same time, the House was by population. That was an effort, a serious effort to balance the interests of the states. We had states that were more urbanized, more industrialized, and they were offset by larger states at the time, very large agrarian, big states with different interests. It was the different interests between these 2 kinds of states. It comes down today, the equivalent is what we might call a red state or a blue state, and trying to find the balance as we have a system of government whereby it's a partnership between states and the federal government, with states being an equal part of that partnership and each state being equal in many aspects of that partnership. The 2 equivalent things in our Constitution are, of course, the Senate, which I mentioned earlier. The second one is the Electoral College. The Electoral College preserves that even the small rural states, the reddest of the red, have some limited number of representation that weighs in and makes presidential campaigns and presidential contests winnable by this rural constituency that we belong to. We've seen that fall apart a little bit lately. And I think it's because we have not approached our differences between red and blue in a healthy manner. I think we're kind of falling into a trap. We're becoming redder while the rest of the nation is becoming bluer. We've watched our Congress and the Senate and the presidency all change to the other party. They're blue. We're red. We're reacting to that by becoming redder, by becoming more insular, by having things like, let's nullify federal laws, even though it's never been done. And the Supremacy Clause puts the kibosh on that. So I've even had people write me and talk about secession. Seriously, let's join the other red states and secede from the Union. Really? What this comes down to is we have to use our legal means to go at the red versus blue, rural versus urban, different historical differences that this country has had since the beginning, and use the tools that our founders gave us in the beginning to address that. All this fear, we are so afraid of, you just name it, vaccines, it just goes on and on. It's not relevant, but we are just so reactionary. What about having a thoughtful dialogue about how we work and balance this divide that has always been part of our country and will be as long as we hold together as one nation? And rest assured, Article 5 has been used before. Article 5 has plenty of safeguards. Do not let these fear mongers and emails you're getting from other states, they're wacko. And they want to have you adopt a nullification, secede from the union, not enforce any federal laws, all of these things. No, let's use the tool that our founders gave us to sit down with our other states and decide on a future path to this country that restrains the federal government. It takes 2/3 of the states to issue a call. That call could be reversed at the very 11th hour if we don't like the way that it's coming together. But most importantly, the true safeguard is in the ratification. Suppose they go nuts at the convention. It's nothing we could live with. Fine, we don't ratify it. 25% of the states can deny ratification. That's an amazing power that the states hold. And as they work to erode the Electoral College, believe me, there are lots of people after that one. The fact that each state has 2 senators seems to not matter too much anymore because we are not in the majority there. Maybe that's our own fault, but we're there. This is the only tool we have that is legal, rational, and thoughtful. Please vote yes.
Further discussion or questions? Senator Hutchings.
Thank you, Mr. Chairman. Neither on or for, against, just some questions I'd like to bring up and hopefully get some answers to. Really love and appreciate the bringer of this bill from Sheridan. But my question would be, who would we send to this convention, Mr. Chairman? And then when we talk about limiting the federal government's power, we have amendment number 10. Just want to know how that comes into play. When it comes to term limits, my question would be, we have an educated electorate, you would think that they would be able to term limit anyone who's not doing or following our US Constitution. And then the balanced budget, just wondering if our Congress is not doing what we would like them to do in regards to our Constitution now, why would they follow amendment number 28? And then I'm wondering where Article 1, Section 9, Clause 7 comes into play when we talk about a balanced budget. Thank you, Mr. Chairman.
Further questions for the sponsor before we go back to the sponsor? Seeing none, Senator Blayman.
Thank you, Mr. Chairman. Oh.
Now
I'll
seeing
yield.
one, I see Senator Perkins. Go ahead, sir.
Thank you, Mr. Chairman. I do have a couple comments and then I do have a question. My question first is, with the emails I've been getting, I'm afraid, Mr. Chairman, that the seas will rise and the continents will clash and the air will catch on fire. And I need some, and so I would like the sponsor, if he would, to find some way to assure me that those things won't happen if this bill were to pass. But the other thing I would just share with the group is, with the Senate is, we've been arguing these things. Will's just been here a little while. We've been arguing these things about at least, not every year, but at least more often than every other year. And Mr. Chairman, gosh, this must have been about 12 or so years ago. I was actually part of a delegation. We were getting really close on a balanced budget amendment about having enough states having to would have done that we actually about 30, if I remember right, about 34, 35 states sent delegates, and we all met at the Capitol in a neighboring state from which you could see the great briny inland sea from the steps of the Capitol. And so there were about 30 odd states of us, that met there. And one of the things that we were doing, we were trying to outline what would happen if an Article 5 convention actually met, what would be the ground rules and how would we do that? And I think there were about 7 or 8 of us from Wyoming that went down and attended that. And we spent a good couple of days actually hashing out. And when a convention meets, you have to actually hash out the rules. You got to have the rules, just like when we meet, we've got to hash out our rules, by which we're going to be governed. And so that was the whole point, was try and get a start on what those rules would look like in the event that we had the requisite number of states, the 2/3 of the states would actually vote to convene the Article 5 convention. And as we met, it was very clear very early that there were significant differences, and even getting to the rules is not going to be an easy task. What was the division? Some of it was red versus blue, but a lot of it was populist versus non-populist. In fact, as we were looking for the number of delegates and the vote count that you would have, we came to an impasse about how many votes per state would each state get. And in fact, the more populous states, about 4 or 5 of the most populous states, their representatives got up and left that meeting and walked out because the majority of the body would not agree to allow it to be a population represented. Your vote would be represented by the number of people you have in your state. And so it blew up. So what I came to the conclusion of that, Mr. Chairman, was that one, it's not an easy task. It's a very heavy lift to even get to to even have a convention. 2 is, once you get to the convention, to have the rules that are going to govern you there is not an easy lift. There are many, many competing interests that will happen at those conventions. And the third observation I would make is, at the end, when you get to the end, whether a constitutional amendment is proposed, as we've done the last 27 amendments, they all came through Congress. But once you get to the fact that you've proposed amendment, whether it comes from Congress or whether it comes from an Article 5 convention, they are proposed amendments. They're not amendments, they're proposed amendments. And whichever way you go, whether you go through Congress or whether you go through an Article 5 convention, what's clear is it takes the ratification of 3/4 of the states before that becomes law. And so as we do that, I really don't think that the fear that people have about this is any more founded than Congress. Congress could come up with whatever they want to come up with and propose as an amendment, as long as you can get the 2/3, just like we've done here. We've come up with some doozies over the years that we've done and gone out to the ballot, and some have been passed and some haven't. And so I don't fear, because I don't fear the people. I believe that I don't fear the people. I've never feared the vote of the people. When they have the right information, they make the right decision. And so, I think in long-winded fashion, I'm going to vote for this, not because there's a couple things in here I don't like. I also believe that when you get to the convention, we've talked about, what's on the chopping block, popular vote for senators and having senators be reflected in population, removal of the electoral college. There's been a number of things that have been proposed. Would those come up? Yeah, they might have come up. In the past, we actually passed a bill that if you went and you voted for anything or you voted to consider anything other than what was amended, we actually, I think, made it a felon, and we threw you in jail for at least a year or 2 and fined you $10,000. So anyway, we were going to send our best and brightest, but by golly, we were going to make sure they did what we wanted, or we were going to throw them in the who's gal. So anyway, there's lots of things out there. It's a great discussion to have. It is a tool that the founders gave the states, that when the federal government began its overreaching, you couldn't get the redress you wanted at the federal level, that it did provide this opportunity for the states then to rise up and propose their own amendments to rein back in the power of the federal government. And so I think that you can vote on this on its merits and not on the fear. Thank you, Mr. Chairman.
Further comments or questions? I'm interested in getting to the fire in the sky. We could use that for an hour or 2 to melt some snow. Senator Rothfuss.
Thank you, Mr. Chairman. I'll be brief on and against the joint resolution. And we certainly have talked about this a lot in the past, and some this might be the first time, but the reality is, in my view, over the years has been, we all share concern over significant problems and disunity and polarization and misinformation and debt and all of the concerns that have been laid out. And when you're confronted with these problems and you feel a sense of powerlessness, then you start looking for solutions. And this is something that is it's a heavy stick potentially that can make changes. The concern I have and have had over the years is, first of all, when I look at all these problems, my first thought is not, well, we've got all these problems, so we really need to fix the United States Constitution. That's not where I cast the blame. I don't see that incredible document drafted by folks that were amazingly enlightened and put together something that has withstood the ages and sustained a country as being the source of our problems. Nor are changes to it the cure for those problems. We look to it as some type of panacea that is going to resolve the national debt and enact term limits and create fiscal responsibility and make everybody that goes to Washington, D.C. all of a sudden honest, hardworking, collaborative and cooperative, capable of being thoughtful and resourceful and appropriately frugal with the country's resources. I have no idea what you would write on a piece of paper that would make that happen, even if you were entering it into the United States Constitution. We're not going to change the nature of humanity. We're not going to change the nature of the people we send there. And furthermore, any process we put forward simply asks that we appoint different individuals to then get together and theoretically propose solutions to the problems. Mr. Chairman, if these individuals exist somewhere that know how to work together and solve these problems, why wouldn't we just elect them here or to the United States Congress or to the presidency or to any of the powers, be them legislative or executive, that already exist and ask that they do the right thing? We want a proxy because we don't like the people we've already sent, but we're empowered as a democracy to change those people. The features that lead to the problems that we have are actually within our power to address. We can work on things like campaign finance reform. We can work on statutes and laws and better relationships and more transparency of information. Those are things that even this body is empowered with. So when we say that we all agree on some changes, first of all, I'll just note that we don't have universal agreement on all of these changes. If we did, they simply would have been a constitutional amendment because once again, we already have a process that is straightforward. The process to amend the Constitution is not conceptually challenging right now. All you have to do is convince 2/3 of the state's legislators, senators, that they need to, senators and congresspersons, that they need to bring an amendment and then get the states to pass it. No problem. If everyone agrees on it, that's easy. It's just that those things aren't out there. Once you start putting pen to paper, it turns out that changing that United States Constitution becomes a challenge. Now, possibility of a runaway convention. I realize that we're trying to cast this as ludicrous and absurd and that nothing bad could ever happen and that it would be fine for the state of Wyoming as it would be fine for all other states. Hopefully things would go well. But again, I see no guarantees. I know how we operate in this chamber. I know how legislating works. I know how working on agreements tends to go. And although there are procedures and rules in place, sometimes there are deviations, sometimes there are different decisions, sometimes there are agreements to go a different way. And to the extent that there really is no script written, Mr. Chairman, there's no idea of how many delegates do we get? Who do we send? We don't know those answers. It would be perhaps more comforting to know those answers, but honestly, even if we did, I don't know where a constitutional convention is going to solve all of our problems such that it would be worth us taking the risk in allowing significant amendments. And, you know, one thing that's often pointed out in this discussion is really the last big constitutional amendment was prior to our current constitution with the Articles of Confederation, which may or may not be a perfect analogy. It's hard to draw perfect analogies, but we know under those circumstances, it was a pretty significant rewrite. When you look at constitutions that have been drafted over the past, say, 5 decades, these are out there, these exist. There are constitutions that we can look at. The United States was involved in the drafting of a number of them. And over recent years, if you're interested in seeing some, I'll circulate them. They do not tend to show the wisdom that was demonstrated when our Constitution was drafted. They have a lot more words in them, tends to sound a lot more like legislation than Constitution. Rights are guaranteed, but only up until the point where they need to be overridden by a legislature that knows better. Honestly, I can't imagine this body would pass the Fourth Amendment if it were written today, or the First Amendment if it were written today. It's not long enough. There aren't enough exception clauses. We like those. So again, I think everybody's probably made up their mind. I wanted to make sure that at least one member of this chamber stood up and voiced a little bit of opposition because I wasn't hearing any yet. I was hoping to. But on and against Senate Joint Resolution. Thank you, Mr. Chairman.
Vice President Hicks.
Mr. Chairman, it's interesting that we're having this dialogue because this dialogue actually started after 1780 when they first sent the Constitution out. So I would like to share you some of the dialogue. It's called the Federalist Papers, designed to convince people to ratify the Constitution of the United States. So let me share what James Madison in his debate to the people of the United States said. And the paragraph labeled in Federalist number 44, the alleged dangers from the powers of the Union to state governments. Thus, each of the principal branches of the federal government will owe its existence more or less to the favor of the state governments and must constantly feel a dependence which is much more likely to beget a disposition of obsequious to the overbearing towards the states. The powers delegated by the proposed Constitution to the federal government are few and defined. Those are which to remain with the state governments are numerous and indefinite. The powers reserved to the several states will extend to all objects which in the ordinary course of affairs concern the lives, the liberties, the properties of the people, and the internal order, improvements, and prosperity of the state. That's what they said we were supposed to have in a constitution and what it was supposed to do. Does anybody recognize that today? But you see, there was this provision in the Constitution that they foresaw at some time in the future that we might have a federal government that just goes off a little course. So they created this little thing called Article 5. Article 5 was designed specifically to address the issues when the federal government gets out of control. Madison articulated what the role of the federal government was and what the state's government. And it does not recognize anything like that today. That, Mr. Chairman, is why the founders gave us Article 5. We should use the Constitution. We should use the Constitution for the very purpose that the founders gave it to us. On and for the bill.
Senator Scott.
Mr. Chairman, just going to ask a simple question. Mr. Chairman, it seems to me that we have an another constitutional convention. Gonna select a bunch of people to go there. There's several states will. They'll want to get something done. We know what a majority here would want to do and what a majority in some of the like-minded states want to do. But we're a very divided country. If you want to get something done, constitutional convention, you're gonna have to make some compromises. And what I ask you to think about is what compromises will be made. Will we have to put restrictions on our spending that will ensure a weak military? Within the charge. Will we have to make it easier to ratify international agreements like the Paris Accord, so that they aren't subject to, if the blue side wins, we're in, and if the red side wins, we're out, and all the consequences that would have. There's quite a number of compromises you can think, well, that might be what you have to do to get what we want. Mr. Chairman, I asked you to think about that as you vote on this.
Further discussion, Senate. President Dockstader.
Thank you. My mind's going back to the late senator who used to sit in that corner and he'd stand up and say, some of my friends are for it, some of my friends are against it. I got a lot of friends on both sides of the fence on this one. This one's hard because, you know, I look at that document that we're talking about is divinely inspired. We have a country because of that. And so as I reflect on all the talk about this, I probably would say there are a lot of good arguments maybe to reconsider this time. Generally been a no. But at the same time, we're delving into something that for me is divinely inspired. And I want to be very, very careful about making any changes to something that could route us in another direction. I'm getting closer. I'm getting closer to this proposal. But if I err, I probably err on the side of saying, let's be very careful about reopening this document for consideration. So that's where I'll be with my vote. I think we're close. And on a lighter note, I look forward to the answers to what will be happening in those natural disasters. Thank you.
Vice President Hicks.
Mr. President, I think my colleague from Bates Creek makes a good point about what's the compromise. But I think, again, we look to history and find out what the compromise was. So let's go back to the Constitutional Convention. So what was the great compromise that came out of there? It's called the United States Senate. That was the compromise position between the small states and the large states that controlled the entire population, because the original proposal was to have one house. So the great compromise was that each state got 2 senators. Geez, I wonder where Wyoming would be today, Mr. Chairman, if there hadn't have been a great compromise with the Constitutional Convention to give the state of Wyoming equal footing with the state of California and the United States Senate. So you see, compromise can be a good thing. Thank you, Mr. Chairman.
Further discussion. I sense you're ready for the question. First, let's let the provider. Senator Biteman, would you like to round it out?
Thank you, Mr. Chairman. Thank you, Senate, for another great debate. We are in historic times and we are in dangerous waters. And I'm here to answer the call for my child's generation. And hopefully they'll look back on this as something that we did right and something that we can do to ensure that this great union of ours will last to see another 100 years. We've heard concerns about who goes. Well, we decide. We're the legislature. We get to decide who goes. How many go, who goes, that's up to us as a body. Yes, we do have the 10th Amendment, and we need to use the 10th Amendment. We need to use it more than we're doing it. We also have to do this as well. We talked about an educated electorate will take care of the term limits problem. Last time I checked, Congress's approval rating was nearing single digits, but yet their incumbency factor is about 96%. So we hate everybody else's congressman but our own. And everybody reelects their congressman and expects a different result. Balanced budget amendment hasn't been written yet. We don't know what it's going to look like. We need the best and brightest from all 50 states to get together and try to draft a balanced budget amendment that works for all of us. And if it comes out of that convention and we don't like it, we vote no. It takes 3/4 of the states to ratify. Armageddon, well, that could happen any day now, I suppose. But I'm tired of sitting around waiting for my fellow Americans to step up and do something. Like I said, when I came in office, the debt was 19 trillion. Now we're at 28 trillion and climbing. And that was because we took the do nothing approach. So are we going to continue that approach, or are we going to try to do something? Obviously, an Article 5 convention is the long game. It's going to take a long time to get to 34 states. And then when we do get to a convention, will we even see an amendment come out of the convention? Can we get a majority of the states there to agree on the language, to draft the language? That's something we can all agree on, to even send it out to the states? I'm guessing maybe term limits might be the only one that comes out of it. We've heard that changes are not the cure. Well, I would have to argue that the amendments to abolish slavery certainly were the cure. It cured it. It was over. So amendments do have value. They do have meaning. They do fix errors in the original document that I agree was divinely inspired. And we do have an amendment that limits the term of office for the president and vice president. And they follow that. We hear arguments that they don't follow the Constitution as written. Everybody's followed that one to a T. We haven't had to forcibly remove a president or vice president yet. And we certainly won't be forcibly removing congressmen and senators either if the term limits gets passed. I believe that's everything. Yes, we are not going to change the fabric of this country by amending the Constitution, adding the 28th or 29th Amendment. We are sick as a nation. We are divided. And that cure for that goes well beyond this document. It's in our schools, our homes, and our churches. That's where we're going to heal this nation. But this is a step in the right direction. Let's do the right thing. Vote aye.
Are you ready for the question? Question being called. All those in favor of Senator Anderson's motion, when the committee of the whole rises to report, to do so with the favorable recommendation of Senate Joint Resolution 2, say aye.
Aye.
Those opposed, no.
No.
Senator Anderson won the loudest. I have a question in my mind. Let's do a standing count, please. All those in favor, stand. All those opposed, please stand. I'm sorry, I'll say it again. because I heard myself, but you didn't hear me. Those aye on Senate Joint Resolution 2 was 14. Those no was 16. Pursuant to SR 6.5, having failed a standing division vote, a roll call vote is required. The chief clerk will call the roll.
Roll call on Senate Joint Resolution 2. Anderson?
No.
No. Baldwin?
Aye.
Aye. Whitman?
Aye.
Aye. Boner?
Aye.
Aye. Bouchard? No. Case? Aye. Cooper? Aye. Driscoll? Aye. Ellis? No. French? No. Murphy? Aye. Guru? No. Hicks? Aye. Hutchings? No. James?
No.
No. Kinsky? Aye. Cole? No. Cost? No. Landon? No. McEwen? No. Nethercott? No. Pappas? Aye. Perkins? Aye. Rothfuss? No. Salazar?
Aye.
Aye. Schuler? Aye. Scott? No. Steinmetz? No. Wasserberger? Aye. President Dockstetter? No. Closing vote? Closing vote closed. Senate Joint Resolution 2, 14 aye, 16 no.
Senate Joint Resolution, excuse me, Senate Joint Resolution 2, having failed the roll call vote pursuant to SR 6-SA, is deemed indefinitely postponed. The next bill for our consideration is Senate Joint Resolution 4. The reading clerk will read the bill.
Senate Joint Resolution 4, School Capital Construction Constitutional Amendment, sponsored by Senator Scott. A joint resolution proposing to amend the Wyoming Constitution to transfer responsibility to construct school facilities to school districts by providing mandatory and optional state funding mechanisms. Was referred to committee number 4, which returned to committee recommendation that it do pass. Ayes, Senators Beitman, Ellis, Salazar, and Scott. No, Senator Rothfuss. Senator Scott, Chairman.
You've heard the reading of the bill. What is your pleasure? Chairman Scott.
Mr. Chairman, I move that we pay the whole. First, I'd like to
Mr. Chairman.
Go ahead, Senator Scott. I just turned his mic on. Go ahead, Chatter.
Okay, Mr. Chairman, I want to start by saying, why do we need this? And I will give you 2 reasons. First, the system we've got now, that we've had since the Campbell II decision. So we've had it long enough to give it a real trial, find out what it's going to do. Is no longer workable, Mr. Chairman, because the revenue source is gone. Just plain gone. Co-lease bonuses was where, not all, but almost all, the revenue for this, for school capital construction came from. Those are gone. There aren't going to be any, not of any significance. So we've got to do something else. Second, what's been the results of the system? We have built, Mr. Chairman, a lot of very nice schools. I hear a lot of complaints about them both in my district and around the state as, gee, it was nice, but it sure cost a lot. We have spent $3.9 billion when you add the school capital construction and the major maintenance. The spending rate there Well, if you figure that at least was no way we were going to get out of spending $1 billion of it, the spending rate turns out to be $250 million a biennium. Where are we going to get that kind of money? I don't see it. I'm open to ideas, but I don't see it. So we need to do something else. What does this amendment do? Well, first, it goes back to the system of local responsibility that we had from statehood, probably before statehood, well before statehood, until the Campbell II decision, Campbell I and Campbell II. That, I think that's the first step. Then, okay, we're going to call a local responsibility, how the local is going to do it. Well, Mr. Chairman, the system that's contemplated, and there are some provisions in case the bond system that's contemplated is a bond system. There's some provisions in case the financial markets are such bonds aren't feasible and we have to do it some other way. But the bond system, that was what was used so that the decision was made by the local voters. So if the bond issue passed and the school building was going to be built, the taxes of the people that voted for it were going to go up. And so, you know, the conventional phrase for that is everybody that votes for it's got skin in the game. And that's a good explanation. And the experience we had was that if the school districts put a reasonable proposal, there were facilities that were actually needed, those bond issues passed all over the state. Little bit of a difference in definition of what was really needed, depending on what the community felt. But I think it was true all over the state. If it was needed, it passed. If it got gold plated, if it had facilities that people thought were not actually necessary, it failed. And then the school board would rework it and build community support and say, now this is what we really need, and then it would pass. That was the experience for years. Now, there was a very real reason that the Supreme Court ruled the way they do. I'm not sure you can really see it in the legal arguments, but we had major problems. This state has very different assessed valuations, depending on where you live. And there was a percentage of the school districts, I'd estimate it as roughly a quarter, but you can argue it up and down a bit, that could not do what they needed to do with the assessed valuations they had. And the state sometimes would help out, sometimes wouldn't, depending on how flush we were, but there was considerable periods where the districts could not do what they needed to. And I think that was in good part the motivation for the court. And I'm trying to read into their mind, why did they do what they did? I think that was a good part of the motivation. It was a problem, and we weren't solving it. What this amendment does is say, okay, we will have an equalization to protect the districts with the low valuation. And we'll equalize them up. The formula that's here is so that if you vote for the bond issue, you pay in taxes what you would pay if you had the average assessed state valuation. And if that's not enough, then the state has to step in, and it is mandatory that the state step in. There's all kinds of ways we could fund it. Could be funded with an appropriation, we had the money. Could be funded with dedicating a revenue source to a fund. But if we don't do that, then there has to be a guaranteed method. And you'd set a mill levy just the same way you do locally to recover what you need to have, pay those bonds off. If you don't have that, you can't sell the bonds. There's a couple of other provisions. There's a provision that we will have the right to look at it and say, are they building things that are more community than school that shouldn't qualify for the equalization? And the way it's written, the implementing legislation, I think, would have broad discretion on what decision we made there. You need that one way or another, because there are facilities around. And the classic example is the auditorium in the high school in my county, which was built in the 20s because the community really needed an auditorium. Very useful for the school, but the community really needed the auditorium. And so they passed a school bond issue to do it. And it worked. School got it, used it, kept it up. Community used it too. It was very useful to the community. They had a struggle to pay the bonds off in the Depression, but that's another issue. And then there's a provision in there. So if there's an undue hardship, say a tornado destroys a brand new school, something like that happens, and that can happen in the state. We could step in and deal with that. Mr. Chairman, that's a very brief explanation of what's in the bill. Let me say a couple of other things. This is a constitutional amendment, so it has to have 2/3 in each house, and then it has to go to a vote of the people at a general election. So if we pass it in this session, it may or may not get all the way through the process. It at least puts this idea on the table. So there's a solution out there. I don't guarantee that this is the best solution, but putting a solution on the table that will work will help us in the discussions to get something that it may be different than this, may be this, that can pass both houses and go to and pass the vote of the people, because that's what we need to do. We have to have a solution that works on the table. This is one I've been hoping since we passed a similar amendment in 2018 that some genius would come up with a better scheme. And I'm still hoping for that, Mr. Chairman. But we need to put something on the table to get the ball rolling. And for those reasons, I'd be happy to stand for any questions, but I urge the Senate to pass this amendment and send it forward.
We are on Senate Joint Resolution 4, discussion on the bill. Senator Landon.
Well, thank you, Mr. Chairman. I always appreciate the passion that my friend from Natrona County brings, and this idea has been around for a little while. I think I supported it in 2018 just to see if we can maybe figure out a way to get that to work. I still have some real question marks about how this would even be implemented or how it would work, Mr. Chairman. I have in my mind a district that really has no assessed valuation, but they love education and they want to build a brand new school. And this, I think, reads that we've got to roll in there and help them. The piece where we have to roll in and help them, that's where I'm getting a little bit of heartburn, because I have a sense that my district would be the one helping. The way it's set up now, Mr. Chairman, is that we handle it on a statewide basis, and we do it through an evaluation system that's pretty intricate. So by the time we find out that we need an addition onto a middle school in the western part of the state, or we decide to build a middle school right here in this town, it's pretty well vetted. It's not perfect. And that's because it comes in here, and oftentimes we throw a project here or there and maybe disrupt what the prioritization schedule is or whatever. But I would submit to you that it's been working pretty well. And we can throw out all the facts and figures about what's been spent, but about half of what the good senator mentioned is just what it costs to maintain those facilities out across our state. I reminded all of you not long ago that we're not paying off bond issues for any of these schools. Every one of our constituents have new schools in our districts that we're not paying off bond issues right now. So that's my caution is we've got a system that's working pretty well. And the thing I like about it, it comes in here. And the 30 of us get to decide whether or not we're going to spend 2% of the value of the building on major maintenance, or we only want to spend 1%. Or if a community really needs a building, we talk about that in here. So that's my hesitation. I'm going to vote this through and on to third reading, but I just have some question marks about, who's going to step in and pay for those districts that don't have assessed valuation and can't really afford to build a building. I'm not sure how that's going to work, Mr. Chairman. Thank you.
Senator Wassenberger. As I find you, sir.
Thank you, Mr. Chairman. Just some questions for the sponsor. Looking at the bill on page 3, lines 2 through 8, the bill talks about a statewide mill levy. And my question is, how much is the mill levy and who levies that mill? And then on page 3, lines 14 and 15, the resolution speaks to the legislature may appropriate funds to relieve hardship. So how is hardship defined? And one of the issues that I have is what would cause a school district to propose, let's say the district we're here in today, which has 800 students in modulars, and they decide they needed 2 high schools, one to the north of us, one to the northeast. They needed 5 elementary schools, and they come up with a package of $240 million. What that would cost is elementary school with 600 kids is about 16 million, and any 4A high school, large high school, is about 70 to 80 million. So is that the priority? How do we pay for that? What happens if a community has a serious need and it's in a large community, say in the center of the state, and they need just 1 elementary school, and they have to pass a bond issue for that elementary school? But because the vast majority of the people in that community go to another school, the bond issue dies or fails. How does that all work? The way we have set up our schools today, there's a very serious prioritization that we follow. And so the best projects, the best schools float to the top. And so I'm wondering how we're going to prioritize that. On page 4, line 11 through 14, the resolution states, this amendment will return school capital construction to local systems with the addition of mandatory state aid to raise the amount raised by the local tax up to what a statewide levy would raise on a per person basis. Why don't we have a handout showing an assessed valuation on the per person basis in our 48 districts? How does that work? Typically in the past, the last question I have is this power equalized? In the 90s, we talked many times about power equalized school system out there that we could build schools with. And of course, all of them failed. And so my question is, how is this really going to work? And so I have some concerns about the bill. But the last thing, the good senator from Natrona County talked about, there is one school out there that has a bond issue, and that's Albany County High School. And they agreed, they received 76 million to build their high school. And actually members of this body was in charge of that and pushed through another 25 million bond issue to enhance their high school, which if you've been to that high school, and that community values education, and they have done a wonderful job with that. So there is one out there. There's only one. There's only one that's passed a bond issue to help itself. So questions for the good chairman. Thank you.
Let's get a couple more questions for you, Chairman. Senator Cost.
Thank you, Mr. Chairman. Being on the school facilities committee and working with it, as well as seeing the schools that have been built in the past, we're more focused right now on maintenance for these districts than on building new schools. And so that funding should be reduced dramatically in the process we're looking at. At the same time, there's some other possibilities that we're talking about in looking at new schools with the idea of, do we do some different things that might put a little more of a control or sideboards on those? So my concern is, if we're looking at the 3.9 billion for the maintenance and the building of the schools and all, and we're cutting back, has that been taken into account as you look at the amount of money that we're looking in the future to be paying compared to what we had to pay in the past? Because we've built the majority of our schools already, and we're hoping for those schools to last somewhere in the neighborhood of 50 years. So that part shouldn't be calculated into what this may end up being in the future. Thank you.
Senator Ellis.
Thank you, Mr. Chairman. Just a few points about why I've been supporting this bill. You know, certainly Laramie County is unique among a lot of communities in Wyoming. Some communities are struggling with people leaving their towns and their communities. That's not the case in Cheyenne. When we look at growth, projected growth, development, we've got it all on the horizon here, and these are good problems for our community. But the challenge is, how do I convince 30 senators in this room to build more schools in my town? When we have these questions brought to voters, for example, through our community college, I can tell you what happens. Either you vote for or against something that the college proposes. And as a taxpayer, knowing that where those dollars come from, you drive by, you look and see what's happening in that particular place. And if you supported the project, you're proud of it. And if you opposed it, at least you have a chance to look at it. The problem we have with our state-run system is there's no nexus between the taxpayers and what they're building. And so I think that's one area of concern of mine is, you know, for the members of the Senate who think that what's working right now is sufficient, I am concerned. What happens when we see projected growth and we have no dedicated funding revenue streams for that? How am I going to ask you, probably through a property tax increase, to impose those requirements on your citizens when those buildings will be built in Cheyenne? I can tell you, if the situation were reversed, I would have more concerns about that. But as we go forward, just a couple of things to note about how it's working now. As was mentioned, this was brought up in large part because of the Campbell decisions. And, you know, we can talk about the fact that we allow local districts this ability to do enhancements as being a good thing. But I'd argue some words of caution that were laid out in those early cases in the 90s. What happens when you start having school districts that allow for enhancements and not allowing other districts who don't have those bonding capacities? They're denied those same opportunities. So we hear about schools that are offering pools, for example. Well, now if you're in a small community, what if pools start becoming the new norm? We've just started raising the bar of what's expected of our state to provide. And so I'd say that we're not in a good spot because there's an inequity that still exists. As we talked about this bill in committee, one point was made was, you know, what if all buildings were starting on equal footing? Senators, that's never going to be the case. In my community alone, there's great disparity in the quality of schools and what's being provided and offered today. I can tell you my kids are attending schools that were built many years ago that don't have air conditioning, that don't have large gymnasiums, that don't have dedicated parking. But we love those schools because of the quality of the teachers that are there. And so as we grapple with these issues, I think a lot of those are better handled at the local level than at the state level. And just one, you know, ongoing concern that I've had is, despite the fact that Laramie 1, the district that I represent, projects growth and sees growth on the horizon, we have no way to proactively plan for that as a community. Instead, we have to wait for those families to show up, and we have to wait for the state to act, if it will act. What happens if it doesn't? So with that, Mr. Chairman, I would urge your strong caution in looking at this bill in a positive light. I know that some of the answers aren't there, but it's because it's being brought in the form of a constitutional amendment. If this passes by allowing the will of the people, voters, to have a say in this, those details will be sorted out in future legislation. So I think this is a positive step forward if we're ever going to truly have more local control over our facilities. Thank you, Mr. Chairman.
Senator Cooper.
Thank you, Mr. Chairman. One of the issues I'm struggling with here is just exactly something that the good senator from up the street here was just talking about, 90-year-old buildings. They're still out there, and some of those schools have been waiting in line for 10 years or more, 15 years, however long it is now, for replacement. We're still in the pipeline. But we've not completed the project we're on yet. It's not time to change this and go to another system when we've not given this equitable opportunity to all the state on the program we have. I'm gonna have to stand against it. Thank you.
Go ahead, Senator Scott.
Well, Mr. Chairman, I'll attempt to answer some of the questions, but I'll warn you that my ability to remember a whole series of questions is less than adequate. There was a question about assessed valuation. We all know what the magnitude of the assessed valuation differences are now. They'll be present. They'll be different 2 years from now when this might first go into effect. I'll guarantee you that. But we'll still have the big differences between some of the districts, and we know that. The question of defining hardship, that was deliberately left open. We need to have an ability to be sensible as a legislature when something out of the ordinary happens that would be a real hardship to a community. If we try to define it, this is constitution, not legislation. We attempt to define it the way you would in statute, we'd get ourselves in trouble because the Constitution has to last. There was talk about, we've heard a lot of talk about, yes, we've constructed a lot of things we aren't going to need so much for a while. And Mr. Chairman, that's true. But you start talking about, well, we ought to have a 50-year cycle or a 60-year cycle or something on replacing buildings. We're going to be spending more than we have been already. And I come back to two salient facts. We cannot continue the existing system. Police bonuses are gone. They ain't coming back. We don't have the money unless you want a fearsome tax increase. Second, you make your own judgment on this. My judgment from what I've seen and from what I've talked to from people all around the state is that we have been spending at a rate people would not approve if they had a chance to vote on it. And there's a reason for that. The system the Supreme Court got us, and they're not good at legislating. They're not set up that way. So they didn't have the opportunity to look at all the pros and cons of the new system they were giving us. We all of us, every one of us, you younger fellows who just came in, you can stop your ears up for a minute, but it doesn't apply to you. But we all of us have defended our home school district. We think that's part of our job representing. And none of us really know enough to say, Laramie County, you don't really need all those schools. We just don't. That's a decision that ought to be made locally by people whose taxes are at stake. The skin in the game argument is very real, and we will get better decisions from that. So maybe there can be somebody can find some genius financing method that I can't think of, that we can continue the existing system. But till somebody comes up with that, this is the choice we've got before us. I urge its adoption.
Thank you, Mr. Chairman. Mr. Chairman, I'd begin by deferring to Senator Boner, who has been trying to get attention.
Senator Boner, go ahead. I'm sorry, I didn't see your hand, sir.
Oh, no worry. You're right on the ball. Just since we're continuing the discussion, I'd like to respond to the comment made by another senator who represents a rural part of the state. I just point out that, the way the system is now, I think that this update, this constitutional amendment would allow more voices for rural districts and not be dependent upon the internal politics of the legislature to determine which schools get funded and which ones don't. It's not, you don't have to be a political genius to understand that with the system being the way it is set up right now, there's probably going to be a lot of those 90-year-old buildings in more rural parts of our state, even as we spend in some instances more money renovating individual high schools than we have renovating the building we're sitting in. And so I just ask my colleagues from rural areas to consider that this constitutional amendment will be a good thing for smaller rural districts that maybe have to share a state senator, for example, with 3 other school districts, 5 other school districts. This is a good step forward for rural districts. But most importantly, it returns this system that we have right now to one that is more balanced. I could have told you as a 25-year-old lieutenant that when you give somebody authority, you need to give them a corresponding amount of responsibility. And when you don't have that, where there's a mismatch, as there is now, where we have all the responsibility for raising revenue and the authority is mixed with this process between state and local interactions between the state government and our local school districts, the outcomes are going to be far from ideal. So I think that this constitutional amendment is a good step forward to begin to reinsert some competent managerial practices into the way that we manage our school construction facilities. And I strongly urge for its adoption for all those reasons.
President Dockstader.
Thank you. Mr. Chairman, must be a politician to go from not wanting to amend the Constitution to wanting to amend the Constitution. So I stand in support of this. This group of sponsors here has, they've gone the extra mile in trying to find solutions for a time of no money. I look at the product holding the flags on my neighbor's desk here, and I think how much that has done for our state and built so many schools in my area and across all of your areas. But unfortunately, folks, the situation has changed, and I hope we can find a solution to help the small districts as we take care of this. I ask for your support of this resolution and the sponsors and call for the question.
And before we question, I believe Senator Nethercott has something for us. Senator Nethercott.
Really briefly, Mr. Chairman, I think the bill may need some additional work, whether you're for or against it, in that I do believe that the amendment needs to possess the ballot question to the voters. In my experience in drafting some ballot questions to the voters, the more precise and concise ballot question for the voters is the best ballot question for the voters. And so maybe we can work on some amendments that narrowly tailors what that ballot question is so that the voters clearly understand. I appreciate the history found there in section 2 associated with the Wyoming Supreme Court opinions, the legislature's findings, all of those being true and accurate. And there's no more money, and I get the need, but we probably need to refine what we actually need the voters to vote on. And so I look forward to working with the sponsors and maybe narrowing that down so that's further clarified for the good people of Wyoming.
Senator Rothfuss, who we've been ignoring here for a few times. Go ahead, sir.
That's all right, Mr. Chairman. Thank you. Mr. Chairman, I have a few concerns about the way this is structured, and if it were strictly self-interest for my school district, I would be an enthusiastic aye on this piece of legislation. It could not be a greater home run for my district, which will pass every ballot measure put in front of it. We'll get a new school each and every year. And some of your school districts would be paying for that for us. So thank you if we vote aye on this, but I do feel nonetheless responsible to stand up and voice some concerns on behalf of the time I've spent on the School Facilities Committee for the last decade, and recognizing that there are some challenges that an approach like this would have. And dating back to before I was in the legislature, and I don't have the full history, and the good tall senator that sponsors this could probably give us a lesson on this, but it's my understanding that when the Campbell decision that required statewide funding of education came through, that there were effectively two options in the legislature at the time. One of those options of proposal was mill levies, statewide mill levies, and that would provide the source of income, which is what we've talked about many times since that for various educational opportunities. And then the other was, well, we've got all this money from police bonuses, that'll never run out, let's do that. And that worked great for as long as it worked, and now here we are again. So we're facing the same challenge, and I think there's a lot of reason for us to seriously consider this. The idea of skin in the game is valuable, and trying to make sure that locals have an opportunity to think long-term is incredibly valuable. We do have flexibility to do that without a constitutional amendment, but we've avoided some of those decisions over the years because they are challenging. But again, we don't necessarily need to change the Constitution to get to those 2 points. And we even added some language a few years ago that requires, if you have a large building project, you have to have a local group working on that. I believe it's for enhancements, but I believe it's also for even if you're building a new high school, you have to have a local planning group get involved and help weigh in and approve the plan before the school facilities department will provide final approval as a way of trying to get some local input. But when you contemplate the formula that's provided here, the idea is that everybody below average gets moved up to average effectively, which again, as I said, is great for my district. Our perhaps most valuable asset is assessed at a $0 valuation. That's a bit of a challenge. Same thing in the community that we're in right here, where all of the government buildings are $0. So bringing us up and then having other districts pay for that would, I guess, be handy. The challenge is it's still not necessarily equitable because you can imagine a circumstance, and this is going to be true of everybody who's below the mean, right? So if you're one of those, think this through. If it takes 5 mills arbitrarily of taxation to build the building that you want to build, then you'll be assessed 5 mills, and then the state will chip in. But all of your people are paying 5 mills for that building. Now go to one of our more fortunate communities that was blessed with quite a bit of resources underneath them. Probably about $1 mill is what those people will be taxed at. Maybe not even $1 mill. It's good to be one of those communities. It really is. The assessment on you will be about 1/5 of what it would be if you're in one of the below the mean. So it still doesn't achieve equity or parity in terms of taxation. Unless, of course, the statewide taxation kicks in, which is in here. And again, kind of an uncontrolled, unpassed taxation. It was skipped over, glossed over a little bit, but that's what backstops this. We don't know how much that would be. That would be a little bit of a challenge. The idea that there's a mystery tax that could come on board or may not, that isn't necessarily voted on by the voters of the state. It's not even in the ballot statement as written right now. Not sure people would be very excited about that. So again, the intent here, skin in the game and finding a solution is good, but is this the solution? And then the final point I would make is we talk a lot as if changing the source of money changes the amount of money needed, but the School Facilities Committee spent quite a lot of time 3 years ago doing a statewide analysis and assessment to calculate the total cost of fleet maintenance over a lifetime. So we're thinking 75+ years. What does it cost to replace all of the schools on a 50, 60, 75-year timeline, depending on the nature of the school? How much major maintenance do you have to put in? And what's the optimization there? And those dollars are going to be the same dollars regardless of where they come from, realistically, pretty close. I mean, you can make tweaks, but at the end of the day, the cost is the cost. We ask for an optimization, we got that optimization. We can share that report, and actually I'll try and remember to do that right after the speech so that everyone's got it. But one of the keys there is about 50% of the costs we're talking about have to be in major maintenance and component to optimize the efficiency of the system. This does not address that, which again is a substantial cost. So it's not a full solution. Mr. Chairman, those are the challenges as I see them. I wanted the body to understand it. Thank you.
Senator Ellis.
Thank you, Mr. Chairman. Just briefly, I think, this gives you something to think about. And we've heard repeatedly, we've got to find a way to get more skin in the game. If not this, then what's the alternative? We talk about having your schools on the list, and I'm empathetic to that. If you look at the list, right now, there's a lot of Cheyenne schools that need major maintenance, they need repair, and we need new schools. So I realize that, those schools have been on the list. But if you go talk to the principals of what's happening in there, we've created a system where there's no incentive to maintain a building. If you put a new boiler in, for example, and you're high on the list, that new improvement all of a sudden means you move down. And so we've created this incentive that it's not there to maintain your schools. I mean, there are some districts that continue to do that, but others that don't. And so that's, when we talk about lack of skin in the game, I think that's what we're getting after. So if not this, then what is my first question. And then the second piece of this is this achieving notion of equity. We are not there. I would propose to you that counties that have immense mineral wealth already have that. We see the balance of inequity. They have nicer facilities, they have pools, they have things that other poor communities don't have. So this notion that we're ever going to fully achieve equity in the quality of our constructed buildings, I just think we need to think cautiously about that, because it's one that's a little unrealistic. And as long as we've allowed for this system for districts to tax themselves for enhancements, we're always going to have this inequity. So I just want to throw that word of caution out there. And if not this, then what? And if you don't support notions like this, then I would hope that in future years, when Cheyenne schools are bursting at the seams, when our classes are overcrowded, that you'll be there to find a revenue source to build those schools. Thank you, Mr. Chairman.
Are we ready for the question? Question. All those in favor of Senator Scott's motion to when the committee of the whole rises to report that to do so with the favorable recommendation of Senate Joint Resolution 4, say aye.
Aye.
Those opposed, no. Senate Joint Resolution 4 has passed the committee of the whole. The next Senate file for our consideration is Senate File 90. The reading clerk will please read the Senate file.
Senate File 90, Hemp Prohibitions and Requirements, sponsored by Senator Cost, an act relating to hemp production, was referred to committee number 1, which returned to committee recommendation that it do pass. Ayes, Senators Cooper, Cole, and Cost. No, Senator French and Nethercott. Senator Nethercott, Chairman.
Mr. Majority Floor Leader.
Mr. Chairman, I move that the committee of the whole beg leave to rise and sit again. I apologize, the clock's an hour off.
Oh, good excuse. You've heard the motion. All those in favor say aye. Aye. Opposed, say no. I didn't think so.
Ed.
Mr. President, I move we stand recessed until 2 p.m.
Announcements. Announcements, Senator Case.
Well, I'm going to fumble through this one, Mr. President. I apologize. We had an announced meeting for Tuesday, which was of course canceled. We'll try to make Thursday be Tuesday, and we'll take up, it's a House resolution, Mr. Chairman, and I wish somebody would help me with the name. I'll get a more proper announcement when we come back, but letting folks know that we're just going to continue our Tuesday meeting that didn't exist to Thursday.
Now it exists. Okay.
I'm sorry about that.
That works.
You deserve better.
You're doing fine. What we missing here?
Mr. President.
Senator Anderson, you digital folks, I keep forgetting. Go ahead.
Yeah, Mr. President, thank you. Your favorite committee, Minerals, Economic Development and Business, will meet today, 15 minutes after adjournment, which should be about 12:45 in Capital Extension Room 4, W4, the west side 4, to hear the following bills: Senate File 141, Business Entities Representation in Detainer Cases, House Bill 10, COVID-19 Large Business Relief, and House Bill 67, Geothermal and Hydro. And 12:45. Thank you, Mr. President.
Thank you, Senator Kinsky.
Thank you, Mr. Chairman. Your Appropriations Committee number 2, or Appropriations Committee number 2 will be meeting in room W113, 15 minutes afternoon recess to consider HB1, General Government Appropriations 2. Thank you, Mr. Chairman. And a re-referral of Senate File 73. Thank you, Mr. Chairman.
Thank you. Senator Landon.
Thank you, Mr. President. Your Transportation, Highways and Military Affairs Committee will meet upon adjournment today in W2 down on the Causeway to take up House Bill 20, Driver's License Requirements, Visual Acuity, and House Bill 135, Tank Co-Leadership Highway Designation.
Further announcements? Senator Case, go ahead.
Mr. President, thank you. The bill that the Revenue Committee will hear tomorrow in W6 in the connector is House Joint Resolution number 3, State Lands Mineral Royalties Constitutional Amendment. Thank you, Mr. President.
Thank you, Mr. Chairman. Further announcements? Further announcements. Okay, you've heard the motion. All those in favor say aye.
Aye.
Nay. The Senate will stand recessed until 2